Yeah, so welcome to the second criminal week, and today we are motivated by a quote from Donald Trump. And Donald Trump, who happens to be the 45th president of USA, and is recently a presidential elect. And one of his popular quotes is that sometimes losing a battle makes you find new ways of winning the war. So that's a quote by Donald Trump, that you have to not be taken away when you lose a battle, when it's your preparation for winning the war. So let me hope that you're motivated by that. Of course, I did not come here to motivate you. I came here to add value to you, and I believe that if you can listen at the end of this video, then I'm going to give you tips that helped me pass the criminal proceedings oral exam. So please bear with me for the next 45 minutes as we unpack this criminal proceedings workshop. So trial proceedings in the Magistrate's Court. This model will further equip students with skills required to manage and conduct trial proceedings in the Magistrate's Court. So we are still within the Magistrate's Court, and we are seeing how to conduct trial proceedings. So basically, by the end of this workshop, we expect you to understand what is the chronological order of these trial proceedings in the Magistrate's Courts, from the time the accused is first brought for reading the charges, the time of pre-taking, the submissions of case of no case to answer, up to going to the full trial, the conviction, mitigating of sentence, and finally the sentencing. So we expect you to have that chronological order, because it's going to help you in passing the oral exams, because they can ask you to make any submissions on anything. So to develop skills required among prospects, advocates, and judicial officers in the performance of various roles during trial proceedings in the administration of criminal justice in the Magistrate's Court. So scopes of week's work: preparation of legal memorandum, advising the DPP, and giving directions to the police. Then drafting of relevant court documents for the trial process in the Magistrate's Court. So basically here we shall be looking at how do you draft these documents for trial. And remember, when we are talking about the Magistrate's Courts, we are looking at the charge sheet. And you have to draw the distinction between a charge sheet and an indictment. And you have to understand that a charge sheet applies in the Magistrate's Courts, whereas an indictment applies in the High Court. So the prosecution and defense of a case before Magistrate's Court. So how do you prosecute a case before a Magistrate's Court? What is your role, you as a state attorney or as a prosecutor of the state? And what is the role of you as defense counsel who is representing your client? So illustration of DPP's powers of exercise of prosecution discretion. And we look at this under Article 120 of the Constitution. That the Constitution gives a lot of powers to the DPP to order for investigations, to discontinue cases, all that. So we are going to look at it and how does he exercise these powers under Article 120 of the Constitution. So conduct of a trial magistrate, conduct of a trial as a magistrate, and exercise of the supervision powers of the chief magistrate. So you have to understand that the chief magistrate has powers, and basically you have to understand also the powers of the magistrates grade 1, because they can sentence up to, there are years where they can sentence up to, and also the fine they can pass. So when the magistrate has exceeded beyond his powers, we do what we call supervisory powers by the chief magistrate. So the chief magistrate exercises these powers by writing the register of the High Court, basically to review the decision of the magistrate. And we are going to look at that, basically where the magistrate has exercised the jurisdiction which is not conferred to him or her by the law. And when we talk about the powers of the magistrate, remember the magistrate cannot try some cases, and also he's limited to granting certain punishment. So these exercise powers will arise where the magistrate has exercised powers beyond his scope. So okay, legislation to consider in preparation of the workshop. Of course, we shall look at the Constitution, and basically Article 23 talks about liberty. So, and when you look at Article 23, sub Article 6 gives you the power to apply for bail. Then Article 28 talks about the right of a fair hearing. Article 120 provides you with the powers of the DPP. Article 129 1D talks about the courts of judicature in Uganda. And also we shall look at Article 212 and 250 of the Constitution. Then we shall be friends with the Anti-Corruption Act, because basically here we are dealing with offenses in the Anti-Corruption Act: embezzlement, abuse of office, causing financial loss, which are all provided for by the Anti-Corruption Act. Then we shall also be guided by the Uganda Wildlife Act. And for example here, when you are in possession of prohibited species, we shall look at these offenses under the Uganda Wildlife Act, and this will be specifically in workshop 2. Then we shall also look at the Firearms Act, when you are in possession of a weapon, so you can be charged under the Firearms Act. And then traffic and road safety, like driving without a license, driving without a license. But of course, we shall not leave the penal code behind. So this is the week of the penal code. You have to make sure that you read the penal code. Then the Police Act, we have looked at most of these sections. The power to order for searches, and how do you carry out these searches, and how do you apprehend a person. Basically, these ones are provided for by the Police Act. Then the Criminal Procedures Codes Act. Basically, we shall also look at the Criminal Procedure Code Act and the Evidence Act, of course, and the Magistrates Act. Then we shall also be guided by the case law. We look at these cases. I think Foundations for Human Rights Initiative versus Attorney General, a very locus class case on bail. Make sure that you read that, and what conditions will you apply for bail. We also have the case of DPP versus Court Chiza Besije of 2005. You know, that was the case where Benjamin Odoch stated that the evidence which was produced by the state could not even convict a chicken thief. So you should read that case of DPP versus Court with that Dr. Chiza Besije. I think it was a rape case. But most importantly here, on conditions for applying for bail. So you read these cases. Most of these ones are online. Abdallah Sulman versus Al, which basically will give you a guide on how to proceed in the instant matters. So then we have the case file number 1, Uganda versus Nshuti Marshall. So at the end of this workshop, the learners should be able to, 1, prepare a legal memorandum advising on the whether or not to prosecute a case. And basically, let me hope that you know the format of the legal memorandum. The real content we always have from to and then legal memorandum, then you head it, then DSI, you proceed, brief facts, issues, and then you proceed to resolve those issues. But basically here, we are going to be advising whether you can prosecute a case. And how do you advise that? Of course, you advise how to prosecute a case by looking on the files you have before you. That's where you go and look into these statements, basically the statement of the complainant, the statement of the investigating officer, the statement of the witness, and also the statement of the suspect. But the statement of the suspect is not always the best statement, because the suspect cannot give evidence against himself. So he will always give a defense. But you have to understand how to play with these statements, so as you can identify the offenses as well as disclose the evidence, so as you can be able to advise whether there is enough evidence to bring charges against the suspect. We also look at alternative dispute resolution, particularly pre-bargaining. And I think we have the pre-bargaining rules, and you have to look at them, because when you want to enter into a pre-bargain, how do you go about that, and how do you agree with the prosecution? And for example, if your client is accepting, so as you can get a lighter offense, you have to look at the pre-bargaining rules, and I think we will have to access them. Then draft relevant documents and prepare a case for trial. So basically here, if we're going for trial, that means we must have a charge sheet. A charge sheet is very important as far as the magistrate's court is concerned. Then prosecute or defend a case before a magistrate's court. So how do you prosecute a case before the magistrate's court? From the process of pre-bargaining, making submissions for no case to answer, replying a submission for no case to answer, and again going for a full trial. We are going to look at all that. Very simple indeed. Don't get worried. Then from there, we shall look at illustrate the exercise of the powers of the DPPs in exercise of prosecutorial discretion. So where the interest where the DPP wants to withdraw a matter, what does he do? Of course, he files a notice of withdrawal and he fills the withdrawal form. So you have to look at also the powers under the Article 20 of the Constitution. And I think if you go to the DPP website, you'll be able to access those documents that the DPP will feel to withdraw a matter. So he has set Anthony at the Anti-Corruption Department as the officer of Director of Public Prosecutions. The above file has been allocated to you by the Assistant Director of Public Prosecutions in charge of the Anti-Corruption Department. 1. Peruse and advise on the following matters. Prepare a legal memorandum advising the supervisor on whether or not prosecute. So basically, the best way you can advise the supervisor on how you can prosecute is looking at the files before you and basically identifying the offenses. And after then doing that, what you do is you evaluate the evidence before you, like what we did really when we are dealing with criminal procedure in first or second week. We are bringing the same habit here to also apply it. So the examiner now, the PAs expect you to have mastered that craft of how do you evaluate the statements and come out with offenses, and also be able to advise whether there is sufficient evidence to prosecute or maybe to carry out additional investigations. So what you have to understand when you're advising, never forget that those laws, Article 28, which talks about presumption of innocence, Article 27, which talks about principle of legality, then talk about burden of proof, Section 101 of the Evidence Act, which says that he who alleges must prove. Look at the decision of Wellington versus DPP and Sechtoriko versus Uganda, where they have re-emphasized that the prosecution must prove its case has the burden. Then also look at the standard of proof. The standard of proof must be beyond reasonable doubt. But at what circumstances does it shift to the defense? And if it shifts on what is the standard? Of course, it's the balance of probability. And this is in instances of insanity where you have to prove on balance of probability. Of course, you have to understand those things for purpose of oral exams. I'm not just singing to you, but this can be your oral questions. So the earlier you understand them, the better. The earlier you understand them, the better. So then the other thing is supposing that you find evidence adequate through the necessary court papers. So basically here we are looking at the charge sheet. So assuming that the accused person has been produced in court for the first time in a role play as a magistrate's court, you must start the process of taking a plea of not guilty. So basically, if you want to understand the process of pre-taking, you must read the case of Adan versus Al. Adan versus Al, it basically lays out the procedural steps that the magistrate must take for you to carry out what we call a plea. But if I can borrow a few times, assume that you're a magistrate. If this person has been produced before you, first and foremost, you have to read the file. This is Uganda versus Abdu Mwesije. So Uganda versus Abdu Mwesije. You are accused of the following. You read the offense as well as the ingredients. Then you ask the accused, did you understand the offense? First and foremost, are you the one called Mwesigwa? Yes, your lordship. Did you understand the offense? Yes, I did understand the offense. Did you understand the ingredients of the offense? So basically, you have to read all these ingredients one by one and ask the accused whether he understood and whether he admits or denies. So after having done that, you enter a plea of not guilty on each ingredient. Then after that, you enter that the accused has pleaded not guilty to the offense and its ingredients. So basically, that's what you do the practical way. But please read the case of Adan versus Ara. It's very conclusive as far as pre-taking is concerned. And you have to read it because it can be your oral question. The panelists can tell you that assume I'm the accused, I'm being charged of theft and have appeared before you. Please proceed and conduct pre-taking. So basically, that's what you do. Ask him the name, read the charge, read the ingredients, ask him whether he understood the charge as well as the ingredients, and then if he admits, enter the charge of not guilty simple as that, and you get your marks. So basically, we're going to assume that the case has been fixed for hearing before magistrates grade 1, and the accused has pleaded not guilty in a mock trial due to the evidence of the complainant in examination in chief and tender in the exhibit of the internal audit report. So basically here at this point, they expect you to have taken you through the moods and you have gotten the confidence and courage to tender in reports or to tender in documents. I remember in my oral questions, I was asked to tender in a medical report of the doctor who was not present. I was very confident, but I also knew that I knew, and of course I moved in my new suit, stood from my chair, introduced myself, and began to examine the person in order to tender in the report. But basically, it's really a simple thing. If this is an audit report, what I do is I say, my lord, I'm Ramsey, counsel for the state, appearing for the state, and the witness is in court, and we are ready to tender in a document. The judge will say, please proceed. I say, my lord, can you please allow the witness to take the stand? The judge will say, please, the magistrate will say, please proceed. After the witness has taken the stand, of course, the first thing is that he will have to take oath. He will have to take oath. Then after taking oath, what you do is you ask the witness, can you please introduce yourself to this honorable court? Then the witness will talk about his name. Then you say, what do you do for a living? Then he will say that I'm an auditor. Then he will say that have you conducted any audits before? Yes, I have conducted many audits before. Then you ask and say that are you because you'll be having the report in your hand. You say, can you identify this audit? You now go to the witness and you give him the audit. Can you identify that audit? He will say, of course he did. How are you able to identify it? I was able to identify it because I'm the one who made it. When did you make it? I made it on this day. How did you make it? I made it because I was called to do this, and I came and appeared, and of course we looked at the matter and I did this. Did anyone help you to make that report? Yes, I made it with my colleague. What was the establishment of that report? They established this. Then the auditor will explain the report. Then after saying that, what shows that you are the one who made it? It shows that I'm the one who made it because I signed on that report. Then you say, my lord, the witness has ably identified the audit report. So I press this honorable court that the report be admitted as exhibit number this of the prosecution. So basically, after having led examination in chief on that report, then you ask court to admit it as exhibit number 1 of the state. So now at that point, they always allow the defense to see whether it has any objections as to the admission of the report. So if the defense does not object to admitting the report, then the magistrate will admit the report, and now it will be exhibit. It will be an exhibit, and now it's evidence which can be relied on by the state. I hope you have understood that. It's really a very, very, very simple thing, but of course you have to practice it. You have to practice it before the mirror. You have to practice it before your friends, because it's by practice that we get better. But if you only read these things and you have never practiced this before, you'll be asked in your orals, and you will look for where to begin from and you will not see it. So I would advise you that try to make oral submissions, tendering these reports when you reach in your room, when you are alone. Make mistakes, but please continue. That's how you get better. I was also fearing how to do this, but through practice, I got better. And if it can happen for me, it can happen for you. I'm telling you. So we are looking at imagine that you have been retained as counsel for the defense by way of demonstration, cross-examine the complainant. So basically, this is the same thing. You are now counsel for the defense. You are cross-examining the complainant. So basically, here you have to understand the difference between cross-examination in chief and then cross-examination. So when you're doing cross-examination in chief, you're asking questions from your client or from your own witness. But then cross-examination is the other opposite counsel trying to pitch loopholes in your evidence. So you have to understand that. So it's a very, very, very simple process. So here now, if you are counsel for the defense and you, after reading this evidence, recorded that and by way of demonstration cross-examine the complainant, that means you are trying to pitch holes in his statement. So, for example, here in this matter, the complainant, we are dealing with a matter of corruption. So you will ask now this person, of course, you said this in your statement, because when you're going for cross-examination, the person has already introduced himself before court. So for you, just hit the nail on its matter. You said in this witness that this person was employed to this, maybe to this company, or do you have any appointment letter to that effect? Then the person replies, can you please produce it before court? Then you say that you gave the person this amount of money. Did you carry out any verification on the same, that money reached the account, and you have the bank statement showing that exact money, the way you talk about it, is it the way it arrived on his account, and you have proof on the same? So basically that's what you're doing, trying to create loopholes in his statement as a lawyer for what? For the defense. Then assuming a counsel for the defendant and the prosecution has caused its case, after reading its evidence, record in court as per the case file, proceed to make submissions of no case answer. So basically, submissions for no case answer, you're basically playing that the state has not disbursed its burden, that has not ably proved all the ingredients of the offense. So I will submit, of course, based from Article 28, presumption of innocence of your client. You proceed from Section 101 of the Evidence Act, which talks about the burden of proof. You call the case of Wellington versus DPP, which says that the state must prove all the ingredients of the offense and beyond reasonable doubt. And from there, you now go to the charges before you, and say that, for example, the accused is being charged of abusing office. My lord, the units of abusing office were laid down in the case of Uganda versus Abraham Biandala, and these are the ones. My lord, as far as ingredient 1 is concerned, the prosecution did not disburse its burden of proving this ingredient beyond reasonable doubt, because they did not produce enough evidence to show that the person really carried out theft. Because, and I hope that my Lord Dishonorable Court finds that ingredient was not proved beyond reasonable doubt. So you do all that like as if you're evaluating the evidence of all those ingredients. Then after that, my Lord, I pray that this Honorable Court find that the prosecution failed to do its duty of proving its case beyond reasonable doubt. So, my Lord, I pray that this court enters, finds that the defense or the accused has no case to answer. Basically, that, as simple as that. You have made submissions practically of no case answer. Please, these things are very easy. You just need to practice them. Criminal law should be one of your sures. You know that criminal law, that one I must teach. I must teach the venting. It's really very easy. It's not hard. It's clear and straightforward. So, assume you are counsel for and prosecution causes this. We have done that. 7. Assuming that your chief set Anthony Soro and after accused taken plea in court, but then you come to the conclusion that it is not in the public interest to proceed with the prosecution of the accused. With the aid of the law and proper documentation, demonstrate the process you would follow to submit the proceeding. We are well aware that under Article 20, the DPP has powers to withdraw a case. So basically, where you you find that it's in the best interest principle, or it's the best interest of the public to resolve the case, what you do, you of course issue a notice of withdrawal, and then you fill the withdrawal form. You have to look at the DPP website. Those forms are there, but basically it has powers to withdraw a case, like we saw of course we have seen it in several instances in political cases where the DPP has come out and withdrawn cases. So it's not the first of its kind. Its dilemmas are likely to arise from the case file, a lot of them, overcharging your clients, secondly, not properly utilizing all the remedies you have for your client, for example, asking for the bail, not properly preparing your submissions, not properly taking pleas, all those things, really very many, not carrying out proper investigations by the police, all those things, really very many. I think at this point you are not still worried of ESCO dilemmas. ESCO dilemmas flow from the facts, and it's not about lawyers. We are looking at lawyers, of course, we are looking at the police, we are looking at the chief state attorney, we are looking at the magistrates. Also bribes are also very rampant in the judiciary. You have heard about that. So preparation for the workshop, the different groups created by the firm leader must meet well in advance to discuss and send by email the firm's presentation to the professional advisors. I think this one is very key for us. We now all know. I think let me just read one statement of the complainant statement, and then I try to give my mind of what offenses I think we shall be discussing. Then I proceed to workshop 2, because I know your time is of essence. Your time is of essence, so I don't want to waste your time. I want to hit the nail on its top and ensure that you get value. So Uganda Police Form 20B sheet number 1. Let me hope you have that you have looked at all the various police forms and basically what they do, because in an oral question they can ask you questions about Form 2B. So what does it entail? But here it has with the complainant statement. You have to understand that it has a complainant statement. That's what you are seeing here. So full name Ekujo Osbat, Chief Administrative Officer, Kumam, by tribe resident of Board Cell, Namnangana Parish. I wish to state that I'm the Chief Administrative Officer of Soro. I wish to say that I'm the Chief Administrative Officer of Soro District Labor. I have been working here. I have been working here for now more than 6 years. I'm the head of the administration and the accounting office of the district. I know something about the administration and accounting office of the district. I know something about the Nyoronza Burangana Road 16 kilometers and Muramba Nyorongoza Road. These two roads projects are government funded for some distant past 2 financial years. My concern is that I saw that the works that should have been commissioned by now are still incompetent. One time in September 2023, I accompanied officials from the Ministry of Local Government and members of the Parliament on the Local Government Accounts Committee of Parliament for site inspection. During the inspection, I saw that the road did, despite the clear design as per approved design, neither did I have a drainage, and yet there was no sign of continuing works on the road. When I returned to my office, I decided to look at the process reports and the designs filed with me by the district engineer regarding the project. I noticed that the works were purportedly done during the period when our equipment was not operational. I wondered how the work could have been done. The project was actually not complete, but all the money was accounted for. I noticed that my signature was also appearing in authorization slips accompanying the engineer certificate. So that's forgery, because I'm also seeing here signature. How do you sign for someone? That's, you are forging someone's signature. So that is not my signature. Those fake documents were used to seek authorization for payment, uttering in false documents. So basically those are 2 offenses. I decided to pass the document to our internal audit and police for further analysis. This is a serious case of theft. That is why I decided to report this case. That is what I can state for now. So basically here we are looking at abuse of office. We are looking at crimes under the Anti-Corruption Act. We shall look at abuse of office. We look at the Anti-Corruption Act, and basically you will be guided by the case of Uganda versus Godfrey Kazinda, whereby the ingredients of abuse of office that accused was an employee of the public body that accused to perform the arbitrary act, and that the arbitrary act was prejudicial to the interest of his employee. Then we shall also look at embezzlement of funds, which is also in the Corruption Act, and we shall look at Abachiche Moses versus Uganda. And basically the ingredients are that the accused is employed by the government, but is still employer's property, and the property came into possession by virtue of his employment. Then we shall also look at diversion of public resources, and we shall be guided by Uganda versus Rwamafa, whereby they say that the accused converted or transferred or disposed of public funds that the purpose was unrelated to for which the resources were intended. We shall also look at causing financial loss by Uganda versus Abraham Biandara. The ingredients are that accused are employees of the government, that in performance of their duties, the accused did an act or mission knowing or having reason to believe that it will cause financial loss. So another offense we can look at is false accounting by public official if you have an accountant, and should also be guided by the Uganda versus Rwamafa, and also corruption. So basically those are some of the offenses I can identify under the Anti-Corruption Act, and also like the way we looked at forgery and uttering false documents by false pretense. But I think basically here we shall have to stick to these these cases and the Anti-Corruption Act. Basically, I think here that's the intention of the examiner, that we should stick in these offenses and the Anti-Corruption Act. So basically that's workshop 2. In case you found this discussion very helpful, please, we have a mastermind group, a mentorship. We always have discussions on Saturday from 4 up to 6 p.m. online. I'll also do workshop 2 on Sunday from 4 up to 6 online. So that means we have students from Barara, we have students from Guru, and even in January we are admitting students from Bari. So please be part of us. It's a very affordable subscription fee, which is going to save you a lot of time by giving you quality notes, by accessing positive members or a community, and also going into a thorough preparation for the oral exam. So please hit me up, and I will be glad to be part of this passing the bar community. So that's it for workshop 1. Please allow me to go to workshop 2. I think that I have done it service. I did not read the other statements. Please read them, but I basically gave you a guide of the offenses you should be looking up to. So workshop 2, the Uganda versus Kaswaburi Gastov. So basically we are looking at that file, Uganda versus Kaswaburi Gastov, and we are looking at, you are the chief. So at the end of this training session, students should be able to prepare a legal memorandum addressing the BPP, and where necessary directing the police on whether or not prefer any charges. So basically we are evaluating evidence. So when you evaluate evidence, of course that's when you can be able to advise whether there is sufficient evidence to bring the charges on the client, or whether there is no sufficient evidence. Prepare the relevant court documents ready for trial. And since this one we are still doing the magistrate's court, it's always a charge sheet. Conduct court proceedings in a magistrate's court and demonstrate the exercise of the supervisory powers of the chief magistrate. We looked at that supervisory powers of the chief magistrate, where the magistrate grade 1 has entered or has exercised the powers that he does not have under the law, or which exceeds the powers he has under the law. Then the chief magistrate writes a letter to the registrar of the High Court, who then reviews the decision of the magistrate. Then prepare relevant documents ready for trial. Conduct court proceedings in a magistrate's court and demonstrate the exercise of the supervisory powers of chief magistrate's court. Prosecute and defend the case and application before magistrate's court, and then identify and address its matters. So your chief magistrate Antoinette Entebbe, you have received the file below for your perusal and advise and further necessary action. So prepare a legal memorandum as to whether or not to prosecute, and when necessary advise the police on investigations and possible charges. So basically how you have to advise areas for further investigations and then the possible charges. Assuming that you find that the evidence is plausible and decide that court action is envisaged, draft the necessary court documents. So basically here we shall be looking at the court documents, and if you are looking at the magistrate's courts, then that will always be a charge sheet. Assuming that the accused has retained you as a counsel and tells you that he's willing to admit one of the offenses preferred, and he's willing to take a sentence of 6 months and a fine. Proceed to advise on how he might achieve a lenient result without a trial. So basically you have the bargaining rules. You have the bargaining rules, you look at them. Basically what you do, you meet with the state and you agree, and then you sign what we call, I think, a bargaining agreement. So where they agree to give him a linear sentence. So basically that's what happened. You have to go into those bargaining rules and you have to read them, but that's what basically is done. Then assume the possession of the magistrate's grade 1 of Entebbe that accuser has pleaded guilty by way of demonstration. Proceed to record the plea of guilty, convict, and sentence the accuser on the charges preferred in A above. So basically here we are also guided by Adan versus R. I think I have already taken you through this process. So basically here you read the ingredients, the offense, the ingredients, and if he has admitted. So remember the decision in Adan versus R, they are saying that you must admit all the ingredients of the offense. So after he has admitted all the ingredients of the offense, then you enter a plea of guilty, and then you proceed to do what? To convict and sentence the accused. And before that, there is going to be mitigation of the offense. This is where the process where the defense is asking for a lighter sentence, whereas the prosecution is asking for a heavier sentence. So I think you have the sentencing guidelines. You have to look at the mitigating factors. For example, if the accused is a first-time offender, if the accused is remorseful, you understand, if he has children to take care of and the family, those things are all mitigating factors. But also the state aggravating factors. One, it's a rampant crime. Secondly, it's a rampant crime, so you should give him the highest sentence. So just like that, you have to understand the mitigating and aggravating factors. That's a lot of the defense of the state. Let me hope you are enjoying this discussion, like the way I'm doing. So assume that you have been retained as an advocate in private practice, you have learned that the accused has been and is still in remand, at Chigo prison since he has been appearing in court for plea. Advise him on the relevant him in a role play in a magistrate's court demonstrate the process leading to the achievement of the envisaged remedy. So basically here we are looking at basically the process of applying for bail. So basically here what you do, remember that bail can be applied orally. When you look at rules of the judicial criminal procedure, rules order can be either in writing or orally. So basically here what you do, you just make oral submissions for bail. Proceed under article, of course, the presumption of innocence under article 28(3)(a). You quote down the case of Florence Biabazire versus Uganda, where the court says that the applicant has a right to apply for bail. Then quote down the case of Dr. Chiza versus Uganda. Conditions that must be met for you to apply for bail. Also have you look at the Magistrates Courts Act. If the person, first the court will look, if the person is a first-time offender, if he has a fixed place of abode, if he has given securities, recognizable securities, getting a letter from the LC1. So you can ask that then the court grants bail to what? To your client. Basically that's what you do. You deliver all submission before the magistrates. So assume that you were successful in achieving the remedy. Assume that you are successful in achieving the remedy. And the grade 1 magistrate has granted you a client cash bail of Ugandan 90 million. And in addition, also ordered to deposit the passport and land title in court. Your client is so distressful and informs you. So basically here, when you look at the case of Andrew Mwenda and Charles Onyongo Obo versus Uganda, it was said that bail should not be like a punishment. It ought to be reasonable depending on the circumstances of the accused person. You look at the case of Kawea Joseph versus Uganda, where the court observed that both counsel and the court have a duty to the accused to conduct the defense diligently in his or her best interest. So basically you cannot give this person money he cannot afford. So what you do is you apply for review of the bail terms, and this application for the review of the bail terms is always in a form of letter to the chief magistrate, and it's always accompanied by an affidavit in support, basically expounding on the fact that your person cannot afford the terms and has a fixed place of abode and has produced substantial securities, and even a letter from LC1. Then you are asking for court to review the bail term. Basically that's what you do. So we are looking here at assume that you are the Chief Magistrate of Entebbe and you receive a complaint involving the accused person, now a convict, upon a perusal of the court file. You discover that on 20th 1st 2024, the accused person appeared before the Magistrate's grade 1 at your station and pleaded guilty to the charges disclosed herein and was sentenced both a fine of 30 million and 25 years prison and daily lashes of the both fine. So basically, how we are looking at this is the same thing I'm telling you, that we are looking at revising this case because the magistrate was overexcited and granted the sentence and fine he's not supposed to give under the law. So you write a letter to the registrar, you as the chief magistrate, where the registrar will look at this file and then review it as far as the sentence is concerned. So it's a form of a letter whereby the chief magistrate writes to the High Court Registrar Criminal Division and he revises the matter. ISCO dilemmas, of course, corruption, making sure that you, of course, defend your client in the best interest, not overcharging your clients, like the way we have talked about. So that's the ISCO dilemma. So let me also allow me to read only one statement of the complainant, so as I can guide you on the offenses you should be having in mind. So in CRB, statement of the complainant that on 20, this is AIP Oketa Robson, that on the 26th September 2024 at about 7 hours, I was on duty with DP Sergeant Mutesi training and duty at Dukumbi near the traffic lights. While on duty, we saw a motorcycle carrying a very big luggage heading toward the Entebbe airport. I stopped the rider and when I asked the men who were speeding on the motorcycle to identify themselves, the passenger was known as Kaswabudi Gastov. I later got to know that he's commonly known as Open Roof around Entebbe. He's a Uganda national. He was holding Uganda passport. The rider introduced himself as Kaudino Brian. I and the police escorted them to Entebbe police station with their big luggage and another suitcase. When I conducted a search of the big luggage and in his purple suitcase, I revised 156 Marokomis long pipes, commonly known as long-footed rats, commonly known as fat mice. So basically, you are in possession of prohibited species. You have to look at the Wildlife Act. It has those offenses: being in possession of wildlife species. And I searched the suspects. I did this in presence of our commander. We suspected it had been combated goods because it was not normal for public to carry or even eat such things. Further research revealed that the suspect had a bolt action pistol underneath his one of Saul's bags suitcase. So being in possession of a weapon under the Firearms Act, we immediately confiscated and seized all the suspect's items and took them as the police exhibits and promptly arrested the passenger. The passenger and his rider were thereafter escorted to the police with the exhibits of the seized items. They were then detained in police custody and the suspect creatures and a pistol exhibited and put in police store pending court action. So basically here we are possession of weapons under the Firearms Act. We also go in the Wildlife Act. There are very many offenses. Being in possession of prohibited species is one of them, but you will be guided. So basically that is it for criminal procedure. Please, I'm waiting you in our mentorship group. Just a small monthly subscription fee to support our research and buy acts as well as buy data of only 100,000 shillings. So basically we allow students from Lira, Mbarara and Kambara, as well as we have already started admitting students from Bari for the general intake. Please be with us. It has been a pleasure as well as a blessing, and I really wish you success from the bottom of my heart. I believe that if you can consistently put in the effort, then passing the bar course is going to be easy. And please, let me end with Donald Trump. Donald Trump quote that sometimes losing a battle can be a preparation for a comeback to win the war. So in case when you misfire in that IA, just revise your strategy, collect your errors, and come back stronger. It happened to me. I misfired, but I came back stronger. And if it can happen for me, it can happen for you. Have a blessed day.